Greetings of peace from the HRM Business Solutions Incorporated, from HR Team Asia and Careers Unlimited. This is our third episode of our HR Talk series. Now, today, I will discuss with you cases on labor relation first before we go into labor standards. Because labor standards pertains to wages, benefits. Labor relations pertains to unions and dismissal of employees. So, this case, which was decided on the 23rd of November last year, 2016, again by Justice Mariano del Castillo, which is one of the most hardworking justices that we have. Always the one writing the decision. And this is about an employee, a managerial employee who posted a derogatory statement against the company in the Facebook. And the question now is this act tantamount to serious misconduct, which would warrant the dismissal of the employee? I will discuss this case in comparison to another case, which is the Visayan Electric Company case, which involves a president of a union who distributed leaflets during Labor Day. Leaflets, Labor Day. It is a statement that denounced the owners of the company, like the Abuites family, which is a very well-respected family in Cebu. And he is the union president. And he distributed these leaflets during the March, Labor Day March. And then the reporters in Cebu picked this up and published this in the local papers. Now, these are very derogatory remarks. It called upon the Cebuanos not to support the increase in the electric power rates in Cebu. It destroyed the reputation of the owners, the management. And so what management did is to file a case of libel. But you know, libel is very hard to prove in court because we need proof beyond reasonable doubt in a criminal case. And so the case was dismissed. But management also initiated an administrative investigation against the union president. Of course, the union filed a notice of strike because they say it is union busting. But management proceeded to dismiss. You know what happened? The Supreme Court decided in favor of management. Your being a union president does not authorize you to destroy the reputation of your employer. I want the union to understand that the freedom of expression does not include the freedom to destroy the reputation of people, especially your employer. On the other hand, this case decided on the 23rd of November 2016. This is a managerial employee. And he posted on the Facebook some insulting statement against a co-worker. Take note, co-worker. In Cebu, it was the owner and the management. Now, how did the Supreme Court decide this case of Interadent? No? The Supreme Court said it is not good, but it is not enough to dismiss. No? Remember, ladies and gentlemen, If the offended party is a higher authority, the penalty is very high. But if the offended party is a lower category, don't believe that everybody is equal before the law. No? Here, it is a co-worker. It is a personal quarrel. It has nothing to do with the company. This is a conflict between two employees. And so the Supreme Court said, okay, suspend but not dismiss. So since you dismiss, you pay back wages, reinstate. That's the decision. So that is the first case. The second case is a union case. Now, this is very interesting case. It's about the union in one of the hotels in Makati. Well, we have the right to share the name because this is a public document. This is a Supreme Court decision. And this is not derogatory to the management, no? This is the Manila Peninsula case. The union, there are two unions in Manila Pen, the rank and file and the supervisors. And now, this union is affiliated with a federation. The federation told the local to increase their union dues because, before it was just 1% of their salary gross. They wanted to make it 2%. And so they had a meeting, and the problem is there was a defect in the meeting. There are very strict protocols when you increase union dues. 3 requirements. First, there must be a motion made and a General Assembly duly called for the purpose. Somebody make a motion. Then it is carried by the General Assembly. Second, the minutes of the meeting should list down those who voted for and who voted against. And then the third one, individually, they have to write a written authorization, not group authorization, but individual, that will authorize the company to deduct. Now, the problem is this. There are other people in the hotel that are not union members, but who must pay agency fee. And if the union members increase by 1% their union dues, necessarily they have to increase. And so these people who are not union members filed a case before the Dole, and the Dole decided in their favor. The Dole says, union, you cannot do that because you did not get the individual written authorization. No, you did not follow the protocol. And this was ultimately affirmed by the Supreme Court. So, ladies and gentlemen, the law protects labor not only against management. The law protects labor from the union. If the union commits a grave error that will redound to a violation of their individual rights, the law will side with the individual, not with the union. So that is a very good lesson. That is the second case. The third case is about illegal dismissal, temporary layoff. We have now jurisprudence. When you lay off an employee because of economic reasons, or because you are an agency and you cannot deploy this person to another company, you are given 6 months. In other words, the period of 6 months, the relationship is not cut off. It's like a boyfriend and a girlfriend, call off muna tayo. No? Pero tayo pa rin. No? Now, if that period reaches 6 months, you have the option, meaning the employer, to pay him separation pay or to deploy him. Now, if you cannot deploy, you have to pay because the law does not allow an indefinite cooling off or what you say, temporary layoff. The word temporary has a maximum of 6 months. Now, if you are a company and you have financial difficulty, like there is a mining company in Surigao whose license was cancelled for whatever reason, or pollution, whatever. Now, what happens to the employees? You cannot draw blood from stone. You cannot get money from the employer when we have no operation. According to the Supreme Court, if there are leave entitlements, use the leave. Once it is exhausted, no, from the time of the temporary closure, you have to count 6 months. After 6 months, you have to have a closure. Closure meaning you pay separation pay. And then if you reopen again, you have the option to rehire him, but that is another relationship. In other words, our conclusion is, hindi pwede yung forever na tayo ay alanganin. Tayo pa ba o hindi na tayo? Kailangang may closure para makamove on tayo kasi walang forever. So, next case is very good. This is SSS benefits. This man was a heavy smoker. He was a heavy drinker. And then he died of cardiovascular disease. Now, you know, under Book 4 of the Labor Code, the State Insurance Fund, you are entitled to death benefits if the cause of your death is listed. There is a document, list of all the compensable death. Or if your disease is not listed, the claimant, who may be your wife, should present a medical testimony of a doctor that will link the nature of your work with the cause of your death. There must be a causal relationship. In other words, you have the burden of proof. You have, it's not like before the labor code. You know, before the labor code, there is a presumption of compensability. If you die before the labor code, there you have no burden. The wife has no burden. It is the employer who has the burden. But the labor code changed it because under today's law, it is not the employer that will pay. Not like before the labor code. It is the SSS, which is the custodian of the State Insurance Fund. Now, the SSS has been charged as the denial queen. Always deny. Then when the SSS deny, what is the reason for denial? They do not want to deplete the fund. But that fund is not an SSS fund. It's not a government fund. It is contributed by the employer every month. No, you know, the employer has two contributions, the SSS and the employee's compensation. The SSS has a counterpart from the employee. That is for retirement. But in case of death, disability, and disease, it is the contribution of the employer without the counterpart of the employee. So why is the SSS always denying? Well, of course, we understand that in this case because the widow was not able to prove that cardiovascular disease and also heavy smoker, heavy drinker. This is a self-inflicted injury, no? In other words, when you are a heavy smoker or a heavy drinker and your wife will, your wife will file a claim, he will find it difficult. But for me, since I am not a drinker or a smoker, my wife does not have to prove anything. If I die as an employee of HR Team Asia or HR Business Solutions or Career Unlimited. And so that's all for the day. And in behalf of HR Team Asia and the HRM Business Solutions Incorporated and Careers Unlimited, in behalf of our President, Mr. Ed Torres, who is the creator of this product, and Mr. Willie Espiritu, our President of HR Team Asia, and above all, our Chairman, Mr. Freddy Marquez. This is Attorney Jimenez thanking you and looking forward to have a more productive sharing. And I welcome questions from the audience and from HR professionals who are interested to contribute in the formulation of value-adding solutions to empower people and organizations. Thank you.